Okay, hopefully you got question number 1 right, which is your name, and question number 2 right, which is mine. Question number 3. The real estate broker's fiduciary responsibility to keep the principal informed of all material facts that could affect the transaction is the duty of disclosure. Disclosure, right? We have obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill and care, right? Number 4, which of the following would be dual agency? And the answer is A, a broker in charge assisting a buyer client in the purchase of a property that was listed by a provisional broker of the firm, okay? So broker in charge can't be designated agent with his own provisional broker, okay? So they have to be what? Dual agents, right? Number 5, if a real estate licensee is an independent contractor affiliated with a real estate brokerage firm, the licensee is solely responsible for all of the following except, all right? The answer here is violations of state law. And the reason is because all of these others, the licensee is responsible for paying his taxes, determining their hours. That's all part of being an independent contractor, setting individual business goals, again. But violations of state law, your broker in charge is also responsible. So you're not only responsible as an agent, as a broker, but also your broker in charge. So you are not solely responsible. There is somebody else there. I promise you that they will let you know if they have a problem. Number 6. Somebody just said that one graded wrong. If it graded wrong, you know what you got, right? If you got a 72.5 and you got one graded wrong, then assume you passed. If you got a 90, good for you. Congratulations, right? But if you got a 50, then one is not, just make sure you got the right answer, okay? All right, number 6, the relationship of a broker to a client is that of we have a fiduciary relationship. We are in a relationship of trust and confidence, right? They have to trust us. That's what fiduciary is all about. And that is our relationship between us and our client. We are a fiduciary. Number 7, a real estate broker acting as the agent of the seller is obligated to render faithful service to the principal. Seller's the principal, right? We have to give faithful service. The entire old car, they signed that, they signed the agreement. So therefore, the answer is the first one. Number 8, a broker is permitted to represent both the seller and the buyer in the same transaction when both parties have been informed and agree in writing to dual representation. We have got to get it in writing that both accept before we can do this, okay? So we can deal with it, but it has to be disclosed dual agency or disclosed designated agency, and we need their authorization in writing. Number 9, a real estate licensee who is an independent contractor with a real estate brokerage firm usually receives D, negotiated commissions on transactions. Right? You're going to get your commissions. You're going to get everything you have, but it's all going to be negotiated, right? Whether you negotiate it with the client who's hiring you or whether you negotiate it with your broker or how their splits are going to be, everything is negotiated, okay? So as an independent contractor, that's what you're going to get. A seller has listed his home with a broker for $90,000, and the broker suggests to a prospective buyer customer to submit a low offer because of the seller's urgent need to sell. Buyer offers $85,000 and then the seller accepts. In this case, in this situation, the broker has violated his agency relationship with the seller, right? He went out and told a customer what? He had an urgent need to sell. Isn't that motivation? Right? Told him to offer less because we have motivation. So price terms of motivation. He's not allowed to do that. Therefore, he has violated his agency relationship with the seller, even though he got an offer and the seller accepted it. Number 11, it's the duty of the agent to disclose to the buyer client all the facts and conditions pertaining to the transaction involving the client. Because why? Well, because we have fiduciary obligations to that principal. We have to tell them everything, right? Disclose it, material facts to everybody, but to our principal, we need to disclose everything, right? That's part of our fiduciary responsibilities. Number 12, a broker who is the agent of the buyer should advise the buyer if, in the agent's opinion, the listing price of the property is unrealistically. As long as they are an agent and we are a client, okay, or they are a client, we are an agent, we owe them advice, counsel, judgment, right? Knowledge, reasonable skill and care, all those things. We need to counsel them. Therefore, we need to do this, give them our opinion. Now, they can take our opinion or not. They can decide that. However, in this particular case, they would make sure that they got that. Number 13, North Carolina broker verbally agrees to represent the prospective buyer, even though the buyer declined to sign a buyer's agency agreement. The broker neglected to revisit the agency issue before showing the property, showing the buyer a suitable property. Therefore, while showing the property, the agent has a fiduciary duty, right? To whom? So this question is a little confusing. A North Carolina broker verbally agrees to represent, all right? So he can show the property under a verbal listing agreement. What can he do? He can't what? Present an offer, right? He can't, right up until presenting an offer. So we can show properties in a verbal agreement. We can do all of that stuff right up till presenting an offer. When we write the offer, we can't present it without a written buyer's agency agreement. So number 13 would be B. Number 14, a real estate agent working for a brokerage firm lists a unit for sale in a condominium building. In this transaction, the agent B is acting on behalf of the brokerage firm, the seller's agent, right? We listed it for sale. That's a tough question, that one, because you got to remember that. Number 15, which of the following best describes the designated agency transaction? And the answer there is D, a broker in charge appointing one agent to exclusively represent the seller as a client and appointing a different agent to exclusively represent the buyer as a client while the firm remains in dual agency. That's the whole definition, okay? Now, whether the broker appoints it or not, it doesn't really matter, right? If a buyer and a seller's agent, buyer's agent and a seller's agent from the same company, it's automatically dual agency. It's designated dual agency because the broker in charge has what? The firm has what? The buyer and the seller, right? They have both. So this one would be D. And the last one, the North Carolina Working with Real Estate Agents document must be given to all consumers in a sales transaction no later than the first substantial contact, okay? No later than that. So hopefully you did well, all right? That one was not very difficult. I didn't think it was difficult. I think I've seen a lot harder questions in agency, so don't give up on agency, all right? If you did well, good. That's where we should be. Okay, we left off the other night. The last thing we talked about was that a broker could not put a disclaimer in the contract that waives liability, that says that we can't be held responsible for anything that happens in this contract. Like, we can't do that in North Carolina. If you do a South Carolina contract, there's an entire paragraph, a pretty thick paragraph about how they can't sue the broker. Well, we're not so lucky in North Carolina, okay? We're not allowed to do that. If we messed up or they think they want to take us to court, they can, all right? We're not going to take that away from them, that opportunity. So we also have to disclose any additional compensation. We have to make sure we let them know, all right, in writing that we're going to get it. So in writing, we could give them, if the builder's given us an offer, we can hand them the offer sheet. Anything that's like that, okay, we do need to tell our clients that we're getting a little, not only are we going to get the percentages, but there's a $500 selling bonus or $1,000 selling bonus, whatever that is. Next chapter, and in chapter 10, actually, we're going to see our sales contract. And in our sales contract, it is 16 pages long, and we're going to go through the sales contract. I highlighted some stuff today that I wanted to talk about when we go through it. It'll take a little bit of time. But please understand, I'm going to show you the National Association of Realtors contract for North Carolina. You offer to purchase and sale, okay? There are 19 topics in there that the state of the North Carolina Real Estate Commission requires. I can write those 19 concepts on a cocktail napkin and it would be a valid contract. So understand that you're going to use probably the NCAR contract, okay, or a contract that's very similar to that. But if you go to a new homes dealer, you might see a different type of contract. If you go to some other place, you might see a different, you may be a trustee, you might see a different kind of contract. As long as those concepts are covered, we don't have to use the North Carolina Association of Realtors form. Matter of fact, only realtors can use it, okay? So it could be, you might see something that looks different, but the topics, the 19 topics will be the same, all right? Rule 58A 112. As long as those topics are in there, I could write it on a bar napkin and we could sign it and it'll all be good. The other thing is brokers must never write in explicit contract terms into the sales contract at the direction of their buyer client. You are not allowed to write anything into the contract other than to fill out the blanks. We also have 14 or 15 addendum forms that you can use for specific purposes that are already filled out. And when we do chapter 10, we'll show you some of those, okay? The point here is that if something is cumbersome and something needs to be written in addition, you need to have an attorney draw up that amendment or addendum, okay? You cannot do it yourself. You can fill in the blanks. If there's a pre-printed addendum form, you can use that. But if there's something that doesn't fit that situation, you may not draft it. Not allowed. That's the illegal practice of law. Has to be done by the attorney. You must show up at the settlement. It would be a violation of your reasonable skill and care clause to not show up at the settlement or the closing, all right? So understand this for closing statements. At the time of the sales transaction is consummated, to deliver to the client a detailed and accurate closing statement showing the receipt and disbursement of all monies, which the broker knows or reasonably should know. When we close, we're going to talk about this in chapter 14 and 15, and then we're going to do one of these in chapter 21. Remember, I don't know, 2 weeks ago, we were practicing proration, taxes, how much, right? We don't close, we got to figure out how many days and all of that stuff, and we'll get some more practice of it. You're going to need to be able to look at a settlement sheet and say, something's not right here. Or this looks right, this looks right, this looks right, okay? Price is right, taxes are right, we made this concession or that concession. You're gonna have to look at that. And we'll do a lot of that in chapter 21, 14, 15, and 21. We'll group those together. Might touch into those at the end of next week, all right? But you'll be able to look at the settlement sheet. You're gonna be able to see it and say, okay, I get this. All right, let me make sure it's all right. And you can't figure out everything, but you can see if something's right or wrong, and you can look at it and say, that's not right. I don't know what it is, but that's not right. Let me bring it up to the attorney. I don't know what title insurance costs today. I have no idea, but I know it shouldn't cost me like $55,000. Maybe it was $1,500 and they transposed the number and it says $5,100. I would know that. So those are the kind of things you're going to have to look at and you're going to have to study, and we'll get into those as we go down. But you're going to be responsible for making sure that that sheet is pretty close to correct. Ladies and gentlemen, my client is going to pay $300,000 for a house. If he finds that I cost him $10 extra because I didn't do the math right, is he going to be mad? He's going to be mad for $10, right? He's paying $300,000. He ain't worried about that, but he's going to be awful mad at me because I cost him $10 extra. Absolutely. Right? That's why these things have to be correct. It matters. We're going to do some closing statements when we do them in chapter 21 next week, whatever. We still got a couple days. When we get into them, they're going to be multiple choice answers. And these are pretty long problems. They're fun, actually. I think they're fun. Anybody who's taken the class before and thinks they're not bad, put it all together. But some of the multiple choice answers, these things are very, very long, and figure you need to put in, 18 to 20 different values in there. And the multiple choice answers are probably like $7 a part. And don't panic, because we'll do them, and we're going to have a good time with them. Don't freak out. It'll be fun. Don't forget our timeshares, okay? Timeshares have to be registered with the Real Estate Commission and renewed each June by June 30th, much like we have to. The registrar is the person who is keeping all the names and of the purchasers. They're responsible for registering each new ownership. All right. And the project broker is their broker in charge, if you will. All right. They supervise it. Understand this. This is another 5 with timeshares. 5 periods over 5 years. You have a 5-day right of rescission. They have to keep the money 10 days. If this is wrong, or they don't register with the state, it is $500 per violation. The Real Estate Commission can fine them $500 per violation. So there's another 5 you need to worry about in timeshares. $500 per violation. So if they register 100 people and they don't tell the Real Estate Commission, it's the only time the Real Estate Commission can fine somebody. They can't fine you, right? 100 times 5 times 500. Look at that. It's $10,000 by forgetting to do that. So again, another rule of 5.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.